Australians die intestate. What does the word mean, and does it matter? Death is a morbid subject, but one that confronts us all, or those closest to us eventually. So why does such a high percentage of us either neglect or reject the notion of putting our death wishes down on paper? And what are the implications if we don't? Who are the people who can help us with the most important document we should leave behind after we are gone? If you imagine someone akin to an ageing male undertaker in the role, you'd be wrong. If the vivacious young lady sitting opposite me is the Sattler files, in the Sattler files is anything to go by. She is Solicitor Catherine Hopkin, Principal of Cariad Legal. Catherine, welcome to the Sattler files. What's a nice person like you doing in such a morbid business like this?
Well, it's not really a morbid business, to be honest. It's probably a bit of a misconception. My role I see as really helping people out well before the stage of death and any morbidity.
Okay. And tell us about the path that took you to where you are today. At what stage did you set your sights on becoming a lawyer?
Well, to be honest, I never really set my sights on becoming a lawyer. I started out as a teacher and loved education. So I loved teaching and I loved learning. And I was very lucky to have access to an excellent education and wanted to share that with others. I continued studying after I became a teacher, and I studied law and was offered work in this field, and one thing led to another, and here I am now.
From the classroom to the courtroom, I suppose.
That's it.
Do you recall the first will you wrote?
I do, actually. It was when I was an article clerk, and I wasn't working in the area of wills and estates. I was working in a completely different area, but I was asked by my supervising partner to draw up a will, and it was really a very basic will, but I remember taking a long, long time researching and studying every single word and making sure I had everything perfect.
This is certainly an area you don't want to make mistakes in at all. I mean, obviously we don't want to make mistakes at all generally, but with regard to an area like this, it's so crucial, isn't it? And there are such deep feelings involved.
Definitely, yeah.
What would be the most complicated will you've had to draw up?
That's a good question. It's interesting because a lot of people that I speak to, a lot of clients, they come to me and they say, my situation is very simple. But more often than not, when I start actually digging a bit deeper and asking the questions that I need to ask, things are a little bit more complicated than people might have realised. And there are things such as, a very common one is blended families. As soon as there are children from previous relationships, new marriages, that can be when things become complicated. Also, I deal with cases where there's children with disabilities, adult children that have perhaps drug or alcohol issues, mental health issues. There are all sorts of different complications that I come across.
Okay. And what are the potential consequences of not having a will? Worst case scenarios, I suppose.
Well, if you don't have a will, it's called dying intestate. And what happens is basically you or passed away, but your family doesn't have any control over what happens. The law actually sets out what happens. And while the law is written in such a way as to do its best to provide for the people left behind, it's not possible to do what everybody would perhaps wish for their families. So I'll give you a couple of examples. If you have a spouse and children and you pass away, in the majority of cases when I write a will, spouses will leave everything to each other in the first instance. If you don't have a will, that's not what happens, which is quite surprising for a lot of people. In this state, and of course the law is different in every state, in this state, the wife only gets the contents of the house and the first $50,000, and then a third of whatever's left, and the remaining 2/3 is left to the children. Now, that can be less than ideal for many reasons. If you think you might have adult children who have got careers and are living their lives, they may not need that money. The spouse left behind may well need that money to carry on living their life. On the other side of things, you may have a spouse who's left behind with young children who, again, may need access to that money to be able to raise their children. If there's no will, that money has to be set aside for those children.
So you've got a myriad of considerations here that you so much.
Yeah.
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 And obviously an expert like you in this area is the way to go.
I would certainly advise it.
Okay. Is it true that you can do your own will or just fill in a form available from a newsagent? What could possibly go wrong?
Well, that's a very good question. There was actually a case last year in WA, and the judge actually, it's a great quote, he basically said that homemade wills are a curse. And it sums it all up very well. They can really cause a lot more problems.
They've been promoted as this incredibly easy option with ads all over the media. They seem very attractive, are they?
Well, they may be attractive. It's that sort of case of you don't know what you don't know. You sit in front of a lawyer and a lawyer will ask you a lot of questions and really get to the core of what your situation is and what you need and what legal advice you need, if any specifically. A will kit is just that, it's a form. So of course a form doesn't ask you questions and can't possibly anticipate all of the potential different circumstances that people have. One of the biggest problems that people have with homemade wills is actually interpreting. People might think, right, I'm writing down on paper what my wishes are, and it's very clear to them in their heads. But of course, once they're gone, there's nobody there left to actually interpret what that person may have actually meant by their words.
I suppose some people could be somewhat afraid to deal with a lawyer and sit down and talk to a lawyer. And in our busy society, they would seem a very attractive option. But from what you're indicating, there are some serious pitfalls involved in going the legal will kit avenue.
Yeah, definitely. It can seem that there's a lot of ideas, a lot of stereotypes about lawyers, and unfortunately, some of them it's with reason. We've got the idea that lawyers can be very, very expensive. They can be, but of course not all lawyers are. We've got the idea that lawyers are perhaps not very personable. Again, they can be, but not all lawyers are the same.
In your case, I would agree. Very personable.
Thank you.
You're welcome.
And I like to be somebody that is approachable and people are comfortable asking questions and also being comfortable knowing that they're not going to be charged in 6-minute increments.
Okay. Could you walk us through perhaps the process when a client comes to Cariad to have you draw up their will?
Yeah, so usually a client would contact me over the phone or by email, and I would have a chat to them initially. I send them out my information, details of my prices and my services, and then I usually go out to the client and visit them at their home or wherever's convenient.
And what information should they have with them at that time?
Well, they need to obviously have thought about the important questions, but in terms of actual information, I don't need specifics such as, exactly how much your house is worth or exactly your superannuation account number. I will come and I will ask for all of the information I need. If there's any information that I need that you don't have at the time, that can always be emailed later on.
All right.
Yeah.
How much do you charge? Let's get to the dollars and cents. How much do you charge for drawing up the client's will? What is the price range here?
Okay, well, as I said, I don't charge for, every phone call, every email. I do fixed prices. So I have basically 3 levels of wills. I find the vast majority of people fit into one of 3 categories. There's a basic will, there's a will with a basic children's trust for people that have got young children, and then there is a more complex will which is for people that have got, maybe a number of different circumstances to which this type of will is suited.
Sure.
But the range is between $440 and $1,320 for my wills.
All right. Is there anyone or anything, dogs, cats, fish, pets in general, galahs, goannas, to whom you can't leave all or part of your estate?
Well, I've recently done a will for a lady who's a vet, and she has a large number of animals. And she wanted to make sure, of course, that if she passed away, that her animals would be looked after. Now, you can't, of course, leave anything to an animal because, well, for obvious reasons. But I can draw up a will that would set up a trust, basically, and the trustee would have control of the funds within the trust to take care of the animals.
Hmm.
On a related note, though, there would perhaps be an issue if you left everything to your horses, cats and dogs to the exclusion of your children. So the answer is yes and no. Yes, you can leave money for different purposes, but you have to keep in mind your responsibilities to your family.
Okay. We're told we must be of sound mind to make a will. What does that actually mean, and who decides whether we have passed that sound mind test?
That's a very good question. You certainly do have to have what we call capacity to make a will, and that's why the majority of the work I do is with people who are perhaps younger than you'd think. There's, you said at the beginning that it's a morbid business. Well, actually, I deal with young families mainly, or people that are at the early stages of their retirement. Once you've got to that stage where you've lost capacity, you just can't make a will. In terms of deciding who's got capacity, it's actually a legal question rather than a medical question. So if a matter went to court and the question was about a person's capacity, the lawyer's notes would be taken, and the types of questions and information gathered by the lawyer would be what would be considered. Having said that, if I ever do a will for somebody who perhaps is of a very old age, perhaps there may be some questions about the capacity, I would always make sure that I also had a doctor's advice and opinion.
All right.
Yeah.
Catherine, the role of the executor versus the solicitor. If all or one of the recipients isn't happy with what they are left, to whom do they complain in that case? You or the executor?
Well, and this does happen, unfortunately.
I'm sure it does.
And I see my role as hopefully preventing that by giving the right legal advice, preventing this from happening. And I would encourage the testator, the person making the will, to have discussion.
This is the potential family battleground, isn't it?
Yeah. And people can
be
very surprised.
This is probably never pretty. No.
And hopefully by setting things up correctly to begin with, you can avoid this. But of course, it still happens. Now, if you're not happy with what you're left, you can complain to the executor, but the executor doesn't have any discretion in what they can do about what is left in the will. The executor must carry out the wishes in the will. So you would actually need to make an application to the court if you're unhappy about what you've left.
So drilling down into that, do you then have to find out what their actual beef is against the executor? If that makes any sense?
So if the beef is against the executor, then that's a different matter.
Right.
So if they're unhappy with what they've been left, then that's nothing to do with the executor. Like I said, they have no control over it. If they have a beef against the executor themselves because the executor's not doing the right thing, not doing their job properly or at all.
I'm pretty sure that's what I meant.
Okay.
Back on track.
Well, in that case, then certainly that would also be a matter of making an application to the court to remove that executor if possible, and have that executor replaced.
Okay. Catherine, is it possible to make a will so watertight it can't be challenged?
That's a question I get asked often, and there's no easy answer. There's never an easy answer with the law. But one thing that is a very easy way to make your will more watertight is by having it drawn up by a lawyer. We talked before about will kits, and there are many, many examples of where these wills just simply fail. A will can be challenged on its validity for things such as fraud. So somebody saying, my dad didn't sign that will. Yep. Somebody else signed it. Or undue influence.
Yes.
My brother made him sign that will. That's not what he wanted. Or lack of capacity. All those sorts of things. Obviously, if you can challenge a will on that basis, it's not watertight. If you've got a solicitor there drawing up the will, then they're going to make sure that all those boxes are ticked, that will has been done correctly.
This seems like such a minefield. And you're having to tiptoe through it all the time. But obviously you get through it, and a great outcome for all parties at the end.
Well, my role is to make what can be a sort of a complicated and hard to navigate process relatively simple, and distill it down into a simple document that's that serves the needs of the individual.
At a time, too, when your client's feelings are so tender and raw, I'd imagine.
Potentially. Hopefully, like I said, people are doing their wills long before they need to, long before they're on their deathbeds. And I certainly have been in the position where I've been in hospitals taking instructions for wills, but it should be part of people's life planning in general. You plan your finances, you plan your budget. This should be just one of those things that you plan. So it doesn't necessarily have to be, and it shouldn't be something that's done at a time where things are emotional and difficult.
Okay, so this is about getting this done as early as possible, not leaving it too late, so that much later in life everything is going to be a lot more difficult.
That's it.
Okay. Catherine, do you have a will? And at what age would you first draw up a will? Or would you recommend that people?
I certainly have a will, yes. It would be very remiss of me not to have a will in my business. And I have a will because I'm over 18, because I own property, and because I have family members and I want to make sure that they're looked after. Basically, you can have a will, you can draw up a will from the age of 18, and really it's important to start looking at your estate planning as soon as you do have assets, assets over, say, $20,000, which, you know, for a lot of us it's not hard to accumulate that, even if we look at things like super and life insurance that can get paid into your estate and become part of your estate. A lot of people say or might think, well, I don't have anything, but they have children. And of course, children aren't money, but you can't put a price on those. So of course, as soon as you've got children, you need a will, because you need to be able to name a guardian or guardians for those children.
So it's planning, really.
Yeah.
And how often, Catherine, and under what circumstances should we change our will?
Well, hopefully, if a will is drawn up correctly and comprehensively, it will take into account different circumstances so that your will doesn't have to be changed every time something little changes. If you move house, it's not always going to be necessary, for example, to change your will. However, there's some circumstances where you definitely do need to be looking at changing your will. People don't necessarily realise when you get married or when you get divorced, your will becomes invalid by law. It's null and void. So certainly the big life events, marriage, divorce, birth, death. So if your executor, for example, if somebody you've named as executor passes away or loses capacity, or your relationship could have changed and you no longer would want that person acting in that position, that would be a good time to review your will. The birth of grandchildren and changes in people's circumstances. So perhaps if all of a sudden you have a significant increase in your assets, you may get an inheritance yourself, then you may want to be reviewing how you structure your affairs and your will.
All right, well, thank you for that. Catherine Hopkin, Principal of Cariad Legal, great to have you on Sattler Files today.
Thank you very much.